Good afternoon, everyone. Welcome to today's webinar, Implications for Louisiana Land Loss Lawsuits and Beyond, analyzing the SCOTUS ruling in Chevron versus Plaquemines Parish. The webinar today is sponsored by the Law and Economics Center at Antonin Scalia Law School at George Mason University. I'm Donald Koshin. I'm the Executive Director of the Law and Economics Center and also a professor at Scalia Law. I'm excited to have you with us for our panel today. I'll be moderating the discussion. This webinar is designed around the mission of the Law and Economics Center, where we serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. All of it centered around the belief that when judges, academics, and policymakers better understand economics and scientific methodology, they're more likely to make sound decisions and to gain more rigorous analysis that supports the rule of law and the free enterprise system. We're committed to developing original, high-quality law and economics research and educational programs like the one today to further enhance an understanding of economics and scientific methodology and provide information that will be useful to legal and public policy debates surrounding these issues. We thank you all for joining us in part of that ongoing dialogue. Today, we'll be talking about the decision that came out of the United States Supreme Court on April 17th, 2026, and what we can expect next. On April 17th, the U.S. Supreme Court issued an 8-0 decision in Chevron USA Incorporated versus Plaquemines Parish, Louisiana, holding that Chevron and other energy producers may resolve Louisiana coastal damage actions, may remove them, from state court to federal court under the Federal Officer Removal Statute, 28 U.S.C. Section 1442A1, because the claims related to oil production conducted under federal direction during World War II, among other reasons. The court concluded that the statute's term relating to had a broad reach, covering even indirect connections. And our panel will be discussing in more detail that ruling. The ruling will allow the cases that have been brought in 42 state court lawsuits to be removed. And these lawsuits, some dating back as far as 2013, seek damages and remediation for activities conducted by the defendant companies allegedly causing harms related to coastal land loss and increased hurricane vulnerability. This panel brings together a group of 4 experts following these cases who will examine the underlying decision as well as the implications for the upcoming implementation of that decision and after effects. So that we can reserve time for a substantive discussion, I will only give very basic introductions to each of our panelists instead of giving extensive bios. I recommend that you click on the link of each of their bios in the materials that we sent to you as part of the invitation to this webinar and confirmation for it, in which you can learn even more about their extensive experience and their extensive understanding and expertise of these areas. We'll start off with Michael Williams, who's the Solicitor General of the Office of the Attorney General of West Virginia, where he represents the state in appeals before state and federal courts, including the U.S. Supreme Court, and including in this case. Mike Fregasso will come next, who's a partner at Torden Law, PLLC, and a seasoned legal and policy strategist, most recently having served as chief counsel to Senator Mitch McConnell. Followed by Melissa Landry, who is a research analyst and policy expert with more than a decade of experience in Louisiana coastal lawsuits and a broader campaign around climate change litigation and public policy and involving the state's energy sector. And finally, we will have Simone Malaz, who is the campaign director of Restore the Mississippi River Delta. She helps support the staff's daily work towards achieving a future Mississippi River Delta that includes a just, climate-resilient coast where people and nature thrive. The panels will each be offering opening perspectives. They will then talk a little bit with each other. I might have some questions for them as well, and then we're going to open it up to audience questions. If you have a question, please use this Q&A box at the bottom of your screen. Please identify yourself. I'll repeat that. Please identify yourself in the text of your message and keep your questions short so that they can be amenable to this virtual format. So with that, I'm going to turn it over to Michael Williams to get us started. Michael.
Yeah, thanks so much, Donald. I get the lucky task of being the one to lay out some of the details of the decision and describe to some extent where we're going forward from here. I think this decision ultimately answered an important but narrower question than I think what some had hoped and left a number of questions to be decided on another day. But I'll tell you up front that the state of West Virginia did, as Donald mentioned, file an amicus brief in this case. We filed that in support of petitioners. So I'm not going to pretend to be neutral about the result. We were happy about what the court decided here in placing these cases in federal courts. But I also want to be honest with you today about what I think the decision does say, what it doesn't say, and then in turn, where we go moving forward. So the basic facts here, you've already heard a little bit from Donald. Louisiana had enacted the State and Local Coastal Resources Management Act, or I guess SCLRCMA, not exactly rolls off the tongue, but it'll work, in 1978. And the act effectively established a permitting program that took effect in the early 1980s, I believe in 1980. In short, this permitting program required that as to uses of state concern, individuals had to actually seek a particular permit from the state of Louisiana before they undertook activities in Louisiana's coastal zone. So it was understood that that permitting requirement did apply to oil production activities. So again, this is a program that launched in the 1980s. The law included an exception for people undertaking those activities who didn't have a permit for, quote, individual specific uses, and this is the key word, legally commenced or established prior to the effective date of the coastal use permit program. So as I understand it, that's effectively a legalese for a grandfathering clause. If you were legally undertaking these oil activities in the Louisiana coastal region before 1980, then you couldn't be held liable for lacking a permit and doing so later on. So fast forward to 2013, and we now have Plaquemines Parish and several others filed several dozen, I think somewhere in the neighborhood of 42 or so, state court lawsuits against oil and gas companies under the act. And these parishes are alleging that the companies, that oil and gas companies did in fact lack the necessary permits for their oil and gas related activities in the Louisiana coastal region. They also argued that the grandfathering clause, and again, this is the important part for our purposes, did not apply, even though the uses started before 1980, because in their view, the activities were not in fact legally commenced. They were looking to things like sort of standard best practices, understandings of obligations in the industry at the time for what ordinary oil and gas producers might have been expected to undertake in the 40s, 50s, 60s, 70s, even moving forward from those times. These parishes were also joined by the state of Louisiana. I believe the Louisiana Department of Energy and Natural Resources also comes into the case and supports the parishes. So state and local governments kind of coming hand in hand to say this coastal erosion permitting statute should apply going back a long way, as far back as we'll see, to the World War II era, actually, of oil and gas production in Louisiana. So I think a key turning point in the case was when Plaquemines Parish filed an expert report in one of the suits that really made it clear that the parishes, or at least Plaquemines, intended to challenge certain crude oil production during the Second World War era. In particular, Chevron's predecessor had refined avgas, so aviation gas for airplanes, sort of high octane gas that was specialized for airplanes, for the military during World War II under a federal contract. And so the question, as it turns out, is really whether those activities become removable under the federal officer removal statute. So of course, defendants removed under the federal officer removal statute, and that statute lets a defendant move a state court suit into federal court if the suit is, quote, for or relating to an act taken under color of federal office. So the suit, by the time it made its way to the Supreme Court, at least, was really over the meaning of the three words or relating to. And those words were actually added by Congress in 2011 in the Removal Clarification Act. And petitioners argued that the change was meant to change what was understood before to be a rather strict causal test, that the specific federal officer had to be kind of the key cause for the actions that were in turn challenged in state court. Whereas respondents said, no, the statute kind of remains as it was before, and it doesn't require that, it doesn't in fact change the strict causal test that existed before, and the strict causal test remains the relevant standard, so the case wouldn't be removable. I think there was really no dispute in this case about the fact that the refining activities were really done under color of federal authority. So really the question for the parishes and for the oil companies was whether the crude oil production itself in the coastal zone, actually digging canals and digging pits and doing vertical drilling, was sufficiently tied to what everyone understood to be the federal contracted activity of refining to justify removal under this federal loss removal statute. So in the end, we had 8 justices deciding this case. Justice Alito, who we think likes to invest in energy stocks, did not participate. So 8 justices decide the case. 7 justices say that, yes, in fact, the production activities were sufficiently tied to the federal refining activities as to justify removal under the federal officer removal statute. Justice Thomas, of course, wrote the majority opinion. He held that the relating to language of the federal officer removal statute sweeps broadly, that it doesn't have this strict causal relationship standard, and that there's no requirement that the federal contract, for instance, specifically invite or demand or require the particularized conduct that forms the basis for the suit that was filed in state court. He also noted that the connection in this case wasn't severed just because the government sat kind of in the chain as an intermediary. That it effectively played the role during the course of World War II of allocating crude oil production among various World War II refineries. But in this case, it wasn't enough that, in fact, that crude oil production did make its way to the refineries, which were then in the Louisiana coastal parish region or coastal region. He did go, a bit farther and stress that the language is not meaningless. It doesn't suggest that any particular kind of ambiguous, tenuous connection would do. In this case, I would say he kind of offered a shot at some people who thought this case was going to be kind of a backdoor reversal of some lower court decisions in the climate context, and seemingly favorably cited some lower court decisions which had held that climate change litigation was not sufficiently connected to federal officer activities to justify removal. So kind of use that as the example of the other end of the spectrum of what's not good enough. But I think we're effectively left with 2 poles, right? It's at the one end, if there's more than, if it's just a tenuous connection, that keyword tenuous is in the opinion, then that's not enough. But if there's otherwise any kind of connection, beyond that, then you're going to at least have an argument that it's removable under the federal officer removal statute. Justice Jackson concurred only in the judgment. She viewed the 2011 statute differently. In particular, she thought that it was focused on making sure that certain pre-suit discovery against federal officers could make its way into federal courts. And she thought that the relating to language that was added in the course of that 2011 amendment really was a conforming amendment that was tied to that separate issue, and that it really wasn't ever intended by Congress to change the causation test in adding that language. Ultimately, she concurred in the judgment because she felt that even if there was a stricter causal test, that in this particular instance, the production and the refining of avgas were so, or the production of the crude oil and the refining of the avgas were so closely connected that, in fact, you could meet that more direct standard. So the Fifth Circuit erred in finding that more direct standard was not met here. So that's the sort of essentials of the decision. I guess where we are next, I'll just offer a couple minutes of thought on that. I think maybe the most important for those who are following the Louisiana proceedings closely is a footnote 5 that Justice Thomas offered, clarifying that the court did not resolve whether the defendants in the other related cases, this non-Chevron, non-Plaquemines context, whether they actually satisfy the standards. So there are still some open questions about sort of the scope of how many of these cases end up in federal court. They also didn't offer a whole lot of comment on sort of the other aspects of the removal test. They did reject kind of an alternative argument that Louisiana had offered, that you had to independently establish this acting under element to get your case into federal court, in addition to the relating to element. And they didn't buy that, but they otherwise kind of left the text of the removal statute as we understood it. So I think maybe most importantly as well for this audience is they did not in any way comment on the merits of the litigation. So this is really a decision that dictates forum, at least for some subset of cases. And that will obviously have effects when it comes to the merits. There's been a Fifth Circuit decision that we might hear mention of later that sort of hinted at where the Fifth Circuit might view the merits of these claims. And I think it also matters, of course, where the jury pools are drawn from when it comes to when we're actually looking at potential liability. But the Supreme Court, of course, did not touch the actual merits of the decision. And then when it comes to the sort of federalism stakes, which are maybe the issues of greatest concern for me as a state, I think it actually kind of went where we wanted them to, and I think is consistent with what the court's been saying in other recent removal cases and even removal cases in the energy space. You might think that as states, we kind of want all cases to be sitting in our state courts, and I think that's a fair assumption in many cases. But there's a recognition on the part of several states that certain issues of sort of inherent national flavor really are best resolved by federal courts. And so when we're talking about national energy markets, for instance, those are issues that really need to be better addressed by federal judges and federal courts who are better positioned to engage with those national issues. And that's what ultimately our amicus brief said. We didn't get sort of a broad exposition from the court on that kind of perspective. Frankly, I think that's one way in which I would have liked to see a broader decision than what we got. But it did, the result at least kind of confirmed the instinct that these federal issues really do resolve in federal forums. I will say that was also consistent with another energy removal decision that the court handed down, the Enbridge decision. I won't get all into the details of that, but in that decision, they ultimately sent an energy-related decision back to state court, but ultimately did so on a sort of timing-focused element that didn't focus on the nature of the issue itself. So it seems like, especially as the court's going to continue to engage with some of these energy-related issues, that the court might be open at least to the notion that, again, certain energy national-focused issues like oil and gas production might better belong in a federal forum. And we view that as at least a partial victory. But again, I think if you're coming away from this with anything, I think it's important to understand that there are just a ton of open issues that are still wide open in these cases. And the real fight, I think, is kind of only just beginning. It kind of resets the playing field on some of the most essential questions. But when it comes to the merits and the liability that these companies are going to face under Louisiana law, that was entirely set aside for another day. So I'll leave it to the rest of you now to argue about it.
Great. Thank you very much, Michael. Mike.
Hi. Thanks for having me. I appreciate the invitation and the opportunity to talk about this. I mean, I think that Michael got that exactly right in terms of how the Supreme Court went about this. It was an interesting decision. It was, again, pretty narrow. I sort of stepping back just briefly, it was an interesting sort of debate between Justice Thomas and Justice Jackson when it comes to how to approach this or relating to question, in that why this was sort of the case she decided to do it in. It seems to be very much part of a broader discussion that the Supreme Court's having, basically most of the court and Justice Jackson, about legislative history and textualism, where she really went into some depth on the legislative history in terms of committee reports and the enacted statutory language versus the final language of the text. And it's sort of people who have been following what she's been up to in recent years know that she is an occasional proponent of legislative history and purposivism, sort of against the grain of the reigning Supreme Court orthodoxy. And I think that this is a good example of that. I think obviously Justice Thomas got it right in terms of what the statute says. But if you want to see what sort of old-fashioned purposivism in 2026 looks like, I read Justice Jackson's concurrence. It's interesting from that perspective. But to Justice Thomas's opinion, I mean, he's pretty clear in it that to remove, you need three elements, right? You have to be acting under a federal officer. It needs to be for or relating to an act under color of law, and you need to be able to assert a colorable federal defense. And this decision really did only deal with that second factor. The first factor, as Michael said, Louisiana tried to sort of throw some sand in the gears on that in their briefing, and the court simply wasn't having it. So it really is just a question of that they decided whether the Plaquemines case in particular was for or relating to any act under color of such office under the removal statute. And obviously they decided that it was. My partner, Bill Barr, was an amicus in the case. He and I believe General Mukasey, or Judge General Mukasey, filed a brief on a lot of sort of the history of what was going on in World War II when Chevron's predecessor company was digging the oil in the Gulf. And it was a lot of that sort of discussion came into the facts of this case and of this decision, and I think very helpfully, right? So the allegations that, you know, the vertical drilling and the canals instead of roads and the earthen pits not being permitted activities, that those were actually very important to the war effort at the time, right? You can't have steel pits when all the steel you have is going to make tanks to send to the European front. So there was a clear relationship there that the court saw, and that's good. But in terms of what that means going forward, again, he was very clear that there was just this case, although the principles will apply broadly. And he didn't really touch on the third prong about colorable federal defense, although that one's, I think, relatively more straightforward. And so what that means going forward is you have a total docket of, the court identified 42 cases in this. I believe it's around there is the current number. About 30 of those cases were in limbo for a while, essentially dual tracking, because there was the federal case where they sought removal. And then there's also the state court cases that were sort of moving along. Roselle was a good example of that. It wound up going to judgment in the state court while the federal removal question was being litigated all the way up to and including the Supreme Court. So you've got about 30 of those cases that are distinct and currently dual tracking. And so those ones are still out there, and they're all going to need to be analyzed according to how the Supreme Court set things out here. So even in this one, you know, there's an administrative stay in Roselle, as I understand it. So the one where the judgment was actually reached. And that one will have to continue to be litigated itself to get into federal court, even though the Supreme Court decided, you know, it's potentially possible they're going to have to prove up not just that they were acting under, which they seem to have that, and relating to, they have that, but they're also going to have to show that they can assert a colorable federal defense, which I think they can. That's colorable is not a particularly high standard, so I think that shouldn't be easy to do, but they will have to do it here. They're going to be doing it in these 30 other dual track cases. And what you have is that the Fifth Circuit didn't sort of take the case on remand and decide they're going to start answering some of these questions at the circuit-wide level. They then kicked it all down to the district courts. And so you're going to have a lot of district courts ruling on these questions to determine whether these particular suits meet the removability standards. So there's going to be a lot of that litigation going forward. They're in, I believe, both the Western District. They're also in the Eastern District. Some of them are from a variety of judges. And then you have these 30 that were dual tracking. There were 9 that were not dual tracking. They were just in state court. They're being re-removed. So those ones are going to have to be analyzed too. And so you're going to have, again, a variety of district courts asking, you know, what's the nexus to World War II here? What was the refining like? Was it integrated refining in these cases? Is the oil traceable? And that will probably be the bulk of them. You have some of these other cases where they don't necessarily have World War II allegations, sort of the lines on the map where the alleged coastal loss took place were not where there was drilling, but so then there's also going to still be factual questions about the extent to which, if those losses took place while the drilling was occurring elsewhere, that did, according to plaintiffs, have effects on the coast. You know, the coast doesn't necessarily conform to lines drawn on a map for litigation. That could still potentially apply. And so I think we'll see what the courts do. I think that the principles are there from the Supreme Court that these cases should be in federal court. I mean, I think that Michael's right, that there is a broader principle at play in a lot of this, that cases involving federal energy development probably belong in federal court for the most part, as a general matter, cases like this one where you have allegations going back to a whole of government response to World War II seem like a very good example of why that's the case. But I think to Michael's point, this was a good decision and an important decision, but it did not solve everything. And now it's going to be 40 little fights in the district courts throughout Louisiana to see whether these cases stay in state court or, as I think they should be, get removed to federal court.
Great. Thank you, Mike. Melissa.
Thank you so much, Donald, and for everyone joining the webinar today. Building off of the points that Michael and Mike have made, I would just add that as we continue to, I think my main takeaway from what's been said already is that yes, the 8-0 decision from the U.S. Supreme Court was very strong and compelling, and is certainly going to, it provides much needed greater clarity for these cases, but in no way does it end this litigation, which has already expanded over a decade. It doesn't end the legal nightmare that we are in, that Louisiana is in right now. And so I wanted to touch in my opening remarks on the real world costs and consequences that has been endured on Louisiana's economy and our jobs as a result of this ongoing legal nightmare. A 2019 economic impact report published by the Pelican Institute documented the economic damage in great detail. It showed that increased litigation risk related to these lawsuits led to between 53 and 74 fewer wells being drilled offshore Louisiana that would have otherwise occurred. And what does that mean? Why do we care? Well, that translates directly into $44 million to $113 million in lost economic in economic losses annually. That's more than 2,000 jobs in the early years of the litigation wave, and up to $22.6 million per year in foregone royalty revenue to state and local governments. That's funding that could have supported schools, infrastructure, coastal projects, many of the things that we desperately need and care about here in Louisiana. So again, that's the estimate is somewhere between $44 and $113 billion in economic losses annually. And that has obviously continued for over a decade now. So the economic impact on Louisiana has been fairly significant. A dear friend of mine, Mike Monclaw, who now serves as the president of the Louisiana Oil and Gas Association, recently testified about his own personal experience before the Louisiana legislature, and directly attributed the bankruptcy, the closure of his family business, and the loss of over 250 jobs directly to these coastal and legacy use. It is clear that these lawsuits are creating a hostile business climate that is discouraging new investment and sending a signal to the global economy that Louisiana is a risky place to do business. It probably comes as no surprise to most of you joining me on the panel today that Louisiana has consistently ranked as a top judicial hellhole by the American Tort Reform Association, in large part because of these lawsuits and overall Louisiana's litigation environment. And so what I would just also add too is that it's clear that this litigation has had impacts far beyond Louisiana as well. In April of 2025, President Trump issued his Protecting American Energy from state overreach executive order. And that executive order sent a very clear message to the states that they must stop weaponizing litigation against the industry that powers our nation and underpins our national security. Clearly, Louisiana plays a very important role to that agenda. Our energy sector drives roughly 25% of the state's economic output, nearly $78 billion in value, and it supports more than 300,000 jobs directly and indirectly. These are high-wage, stable positions that sustain families and communities. Yet, the coastal lawsuits create exactly the kind of hostile and uncertain legal environment that President Trump's executive order was targeting. The $745 million verdict in Plaquemines Parish last year sent a chilling effect that even lawful permitted investments in energy production made decades ago can trigger massive retroactive liability. With dozens of similar cases that are still pending in our courts right now today, and as these cases are being removed from state courts back to to federal courts where they belong. It does, though, that $745 million Plaquemines verdict is still out there, and it's the threat of billion-dollar judgments continue to deter new capital here in Louisiana, and we hope not America more broadly. So the impact of the coastal lawsuits is clear, not just on Louisiana, but America as a whole. And as we talk about kind of get into the legal the legalese of it all, I just wanted to kind of bring us to that point that I don't want that part of it to be lost.
Thank you, Melissa. And I want to remind everyone in the audience that you can use the Q&A button at the bottom of the screen to submit your question. Please be sure to identify yourself and your affiliation, and then pose your question. And as soon as we are done with opening remarks as well as interpanel discussion, we'll turn to those questions. To lawyers who are hammers, everything sometimes looks like litigation as a nail. And so I think Simone's going to offer a perspective as to why perhaps sometimes our focus on litigation deflects our understanding of alternative ways to solve some problems. So Simone, why don't I let you take it from there?
Yes, thank you, Donald. I appreciate that transition to what I'm going to talk about, because I'm going to step away from the legal side of it and talk a little bit more about the science and the policy of what's actually happening on the ground here in coastal Louisiana. So I'm going to start with just a very brief introduction of myself and the work that I do. My name is Simone Malaw, as I said, and I was born and raised here in South Louisiana. I currently serve as the campaign director for Restore the Mississippi River Delta. It is a coalition of science, policy, and outreach experts working to secure a more resilient future for Louisiana's coast, communities, ecosystems, and economy. And we've been working on coastal issues here in Louisiana for more than 15 years as a coalition. And many of our staff, like me, are based here in New Orleans, but our team works throughout Louisiana, across the Gulf Coast. We have representatives in Washington, D.C., and beyond. Personally, I myself have worked in coastal Louisiana on restoration and resilience for over 20 years, and I've had the opportunity to serve in a couple of different advisory roles, including contributing to Louisiana's coastal master plan process. We'll talk about that in a little bit. And again, my role here today is to provide some additional context about our literal coastal landscape. where we are today, the challenges that we face, and some solutions that remain available to us. So to talk about Louisiana's future, it helps to understand our past. And you probably already know that Louisiana's coast was created by the Mississippi River. Over thousands of years, the river built the delta by carrying sediment from the heart of North America and depositing it into our wetlands and our coastal basins. Because of that natural process, there's never really been a status quo in coastal Louisiana. Change has always been a part of our landscape. But next year marks a century since we fundamentally changed how we managed the Mississippi River. Through levees and water control structures, we've largely disconnected the river from the wetlands that have depended on it for that delicate balance of freshwater and sediment. Now, there's no denying that those actions brought tremendous benefits. They improved navigation, they reduced seasonal flooding risk, and they supported economic development. But it also came with unintended consequences. By cutting off that natural land building process that created coastal Louisiana in the first place, we've accelerated land loss across much of the Delta. So that human impact, along with sea level rise, subsidence, and hurricanes, Louisiana is now losing land at an alarming rate, and the stakes couldn't be higher. What's at stake here in coastal Louisiana? The coast supports approximately 26% of the continental U.S.'s commercial fish landings. More than 2 million people live along the coast here in coastal Louisiana, and that coast supports a tourism industry worth roughly $17 billion annually and facilitates approximately 20% of the nation's waterborne commerce. But this isn't just a Louisiana issue. What happens here in the Delta affects communities, industries, and economies across the country. And the good news is that Louisiana has not ignored our challenges. Following Hurricanes Katrina and Rita, our state fundamentally changed how we approach the problem. We recognize that no single solution would be enough. We need both protection and restoration. And what that means is that we have to invest in levees and floodgates and risk reduction infrastructure while also restoring our multiple lines of defense, barrier islands, rebuilding marshes, protecting shorelines, and plans to reconnect to the Mississippi River in a major way so those wetlands can be reconnected and replenished of sediment and fresh water. So when we did this, Louisiana created one of the most comprehensive coastal planning processes in the world. We doubled down on that investment through a state law by saying that we had to have a science-based coastal master plan that is updated regularly. It incorporates public input and is informed by the leading scientists, engineers, economists, and subject matter experts from around the globe, but also from right here in Louisiana's coastal communities. This comprehensive plan allows us to evaluate projects using the best available science and to make informed decisions about where and how to invest our limited resources. As you can imagine, none of this comes cheaply. The challenge facing Louisiana is enormous and the price tag is substantial. Yet for 2 decades, state leaders, federal partners, local communities, and advocates have worked diligently to secure resources needed to make this progress. Simply said, we put our money where our mouth is. But importantly, Louisiana also established safeguards to ensure that funding is used for its intended purposes. Those protections have helped us build public trust and confidence in the coastal program, and that trust really matters. Last year, our coalition conducted statewide polling that demonstrated something many of us have already long believed, that coastal restoration here in Louisiana remains one of the few issues that unites Louisianians across geographic, political, and demographic lines. It is not a bipartisan issue. It is a nonpartisan issue. More than 90% of those surveys agree that it is important for Louisiana to maintain a plan to address coastal land loss that keeps pace with the latest science. People understand what's at stake. They want those solutions to be grounded in facts, science, and long-term planning. But at the same time, we've seen some significant changes in Louisiana's coastal program over the past couple of years. Three major projects, three diversion projects, including two major sediment diversion projects that were designed to reconnect the Mississippi River with adjacent wetlands, have been canceled by the current state administration after hundreds of millions of dollars have already been invested through Deepwater Horizon funding. Recent polling, also conducted by our coalition in 2026, indicates strong public concerns regarding those decisions. The survey found that nearly all voters in the poll, 98%, believe that the state should clearly explain how Deepwater Horizon restoration funds should be used. 93% believe the state should publicly report how much money is being spent on coastal restoration projects. The polling also found that 76% of voters oppose the decision to cancel those projects, while 73% support continuing Louisiana's science-based coastal master plan approach, big projects for the long term, when compared to alternative shorter-term strategies. Regardless of where individuals stand on any particular project, these results highlight two important themes: that Louisianians value transparency and they support a science-based planning for the future of our coast. I just want to leave you with this final thought. From one end of the state to the other, from Lake Charles to Morgan City, from Houma to New Orleans to Plaquemines, the actions we take today will shape the future of Louisiana for generations to come. This is not about preserving Louisiana exactly as it exists today. The coast has always changed and will continue to change. The question is whether or not we make thoughtful investments that give these communities more options, more information, more time, and greater resilience in the face of an unknown future. Our future is not predetermined. It's shaped by the decisions that we make now, whether we continue to invest in science, whether we act at a scale that matches the challenges before us, and whether we remain committed to protecting those people, places, and economies that depend on our remarkable landscape. Large-scale restoration projects remain the most important tools we have to reduce risk, strengthen resilience, and build a more sustainable future. We have so many challenges here in coastal Louisiana, but our opportunity is also significant as well.
Well, thank you to all of you for getting us started with those opening remarks. I think we've learned a lot about where we stand and where we've been and where we're going. With that, though, before we move into any particular questions, I have a few, but I wanted to see if anyone heard anything from another panelist that they'd like to reply to, and or whether or not there's something that another panelist might have said that sparked you to think of something that you left off your remarks.
Simone, I just have a quick question for you. That was fascinating. I had read about canceling those large-scale diversion projects from Deepwater Horizon. Do we have any idea why?
Yes, that is the million, or I guess the $3 billion question, Mike. We went through an extensive permitting process, 6 years to obtain a permit. And these ideas, these sediment diversions, are foundational to every science-based planning project since both we created the master plan and beyond. And so one of the projects was literally already under construction in Plaquemines Parish, and then they received a pause and then a suspended permit, et cetera. And so I think there were a variety of reasons given by the state, but it seemed largely political in nature.
Any other responses or questions to each other?
Thank you. I was just going to add, and so thank you so much for giving the background on Louisiana's coastal master plan. It is such an important tool to help really rebuild and restore Louisiana. I was really privileged to be able to work for the governor's office and with the legislature in passing the legislation many years ago in the aftermath of Hurricanes Katrina and Rita. And it was really an effort that brought everybody together, as you so eloquently pointed out. It still shares support across the political spectrum. I just wanted to add that the number one private investor in Louisiana's coastal master plan is, in fact, the industry, the energy industry. While these coastal lawsuits have not generated anything to restore a single mile of Louisiana coastline. Louisiana's energy industry has always been and remains the largest private investor in coastal protection and has contributed more than $4 billion to restoration projects since 2009, with an estimated $200 million annually going forward. And I just add that as a little nugget, a data point to further suggest that it's really not these courtroom battles that are going. These courtroom battles do not protect our communities or rebuild our wetlands. I think they're incredibly effective at producing payouts for lawyers, but very ineffective at actually producing positive, productive solutions that actually help our communities.
I was going to say, listening, it sounds like a very sophisticated and effective way of approaching the coastal issue. And you've got scientists involved, economists, policymakers. Seems to me the people I don't want involved in this are trial lawyers, but otherwise seems like a great general approach that Louisiana has been considering for how to deal with this issue that, as you say, has been going on for over a century.
Yes, within our system of separation of powers, I think we sometimes we lose the idea of comparative institutional competency and whether or not there are some branches better at doing things or some sort of institutions better than the courts and the trial lawyers to accomplish some of that.
I think West Virginia might take issue with that. We've been fighting that fight for years.
Yes, indeed. So I have a couple questions about sort of just categorizing next steps. And I think that this is mainly a question for Michael and Mike. So we have a spattering of cases that will be at different stages for the next, unknown period of time coming forward. But there's basically several steps involved here, right? First is determining whether or not they're going to ultimately end up in federal or state court for all of these lawsuits, right? So the basic jurisdictional question there. Once that's resolved, can you help us understand each of the next steps that you expect to happen? So once something is firmly inside, say, a federal district court, is the next step dispositive motions to dismiss, and what kinds of merits or jurisdictional issues will be involved in that category? Then I suppose there's a next layer of summary judgment motions, which will be slightly different. What might be in that bucket? And all of that I expect is going to happen before any of these things actually ever get tried to the merits. So if anything does go to the merits, I would expect it's probably many years away. Is that true? And if it is, can you help us understand what's in each of the upcoming buckets going forward?
Yeah, I think that's right. I mean, I think the thing to keep in mind is that there's a lot of parallel things going on that are going to be going on not at the same time. And so you've got 40 of these suits out there. Again, 30 of them are ones that were previously dual tracking. 9 of them are being re-removed. The Western District ones are all in front of one judge, but Eastern District ones are all in front of different federal judges. And so you're going to have the variety of federal judges with their varied approaches to how long they like things to sit out there answering these. First, the removal question. So they're all going to need to deal with whether they belong in federal court to begin with by satisfying that they have a similar related to nexus as so non-causal nexus as Chevron and Plaquemines, and then what their colorable federal defense is. Then they'll, if they can stay in federal court, they'll do a motion to dismiss based on their colorable federal defense. After that, go to, as you say, summary judgment, and then eventually to trial. But again, you've got a lot of them going on in a lot of different courts at a lot of different speeds. Some of these will wind up making their way up to the Fifth Circuit. I think it's an open question whether the Fifth Circuit's going to want to deal with, potentially 39 different appeals on questions of law about federal removal to begin with, before you even get to the federal defenses. So you'd like to think that at some point the Fifth Circuit is going to start realizing that this is unwieldy and maybe start consolidating and giving some more clarity in terms of what the actual legal requirements are to make things a little bit easier for the district judges. But that'll all be going, and again, hopefully these cases stay in federal court for a variety of reasons. If any of them don't go into federal court, those ones will go in the state court. Again, in the Roselle case, the plaintiffs did not want it, the judgment stayed. They did, as I understand, like they'd agreed to do a stay until 30 days after the Supreme Court decision, and they didn't want to continue it. So they wound up, I think Chevron had to go up to the federal court to get them to stay the state court judgment on the case, where it's very possible they could be removing it to federal court for the Supreme Court, to just sort of give you a taste of how sort of gratuitously complicated the stuff can be down in Louisiana, dealing with Louisiana state courts. So I think it's might be a somewhat unsatisfactory answer, but we can kind of know big picture what's coming, but there's so much variability. I think in part, going back to one of the first things Michael said, in terms of the narrowness of the Supreme Court's decision. There's so much variability in how these cases are going to wind up being litigated, both at the federal and then potentially still at the state level, that it's going to be a while until we know much of anything.
I guess I would just add, it will be interesting to see if this decision sort of acts as a prompt for some sort of informal resolution. I mean, my understanding is that there is an agreement in principle as to some of the defendants that came just after the Supreme Court decision. I think Exxon in particular reached some potential terms with the state on some resolution of at least some of the claims. It's a little ambiguous to me what the scope of that is, but if you start getting some of those resolutions, they might kind of act as bellwethers, and then you might start seeing the ball moving faster and faster. Whether that's a good thing or not, I guess depends on your perspective, but oftentimes it's just like that one first mover gets things rolling.
So quick follow-up on that. If one or even a small number of the defendants settle, there's quite a wide diversity of defendants in these cases, correct? And do you see that any one particular settlement, perhaps it changes, it provides information, sends signals, or otherwise changes the climate for all of this? But do you see otherwise any individual defendant settling having an impact on the other defendants?
I guess I would say yes. From my perspective as an outside observer, there are certain defendants who are known to be more aggressive than others, and maybe, candidly, maybe more sophisticated than others. And so I think if you saw a highly sophisticated, ordinarily aggressive defendant who suddenly reached some resolution in a case, that might be a cue to the others to hop on board. I won't name names, I guess, but I think there are certain defendants who I think would provide a significant signaling effect if they either settle or have some big loss or something like that.
I would just add, while there have been some recent announcements involving some high profile defendants, some of our friends on the other side are suggesting that, that in some way minimizes the importance or the ongoing impact of this litigation. I would just say that, that the importance of the litigation has not been diluted or diminished in any way. I mean, the fact of the matter is there are still lots of active cases targeting nearly 200 defendants collectively. And we're talking about major companies facing multiple suits, Chevron alongside others such as LLOG, numerous BP entities, Devon, and a variety of Louisiana-based operators. So it's important to just keep in mind that this is not a narrow dispute. This is this litigation has been from the very beginning, has targeted Louisiana's entire energy industry as a whole. And so this, it's a coordinated wave of litigation that has and continues to have national stakes.
Simone, when you hear
to that point, different people have different appetite for paying ransoms, essentially. And the trouble is you have to calculate, does paying the ransom encourage future hostage taking? And I think different companies will have different approaches to how they answer that question. But it'll be interesting to see how it plays out.
Simone, when you hear about sort of this continued wrangling and the long time horizon of all of this, how does that sit with the prospects for on the ground, sort of progress?
Yeah, we know that we have a certain level that we have, for us to keep pace with the challenges that we're facing. It was, once said that we need to spend about $1 billion a year of continuous investment on both the restoration and protection side. And y'all were talking about settlements earlier, and some have settled and some are certainly pending. And the oil and gas industry is a major landowner here in coastal Louisiana. And so sometimes that actually literally impacts the places of those projects and where we can build those projects. And so I said it earlier, we have lots of challenges here, and we certainly have a complex future moving forward. We have confidence in this science-based master plan that has been vetted in so many different areas, and to stick to that plan and to continue making investments in that area is very important to us. And so the politics and some of these other things, I guess it's easy for me to say, are distracting from this one major thing that will dictate Louisiana's future.
Thank you. And I have several other questions for the panel, but I'm going to refrain for now and interject them if we end up needing to fill some of the space. But I want to remind the audience you can use the Q&A box at the bottom of the screen. I have a couple of questions that have been posed by the audience so far, and I'll pose these. I think that this first one probably goes to you, Melissa, and anyone else can chime in if they have some thoughts. But an anonymous attendee has asked, do you think the economic impact of this litigation is exaggerated? And again, I will remind the audience, please do identify yourself and your affiliation, but I'll go ahead and take this anonymous question and throw it over your way.
Interesting question. I really do not. When you look at the massive amount of investment and increased production that has taken place offshore. So we're talking about essentially just not a different part of the world, not a different region, but very short distance away. It's been significant and has grown tremendously. At the same time that production has declined in South Louisiana on onshore waters. And so, and that has been a consistent trend that is borne out in the data and the research. And so, and then, you look at the reasons for that. And, folks have consistently, consistently discussed Louisiana's the legal and regulatory climate as a major deterrent for investments in the state. And so I would just encourage and invite folks on the webinar today to visit pelicanpolicy.org to look at the underlying data that is supporting that economic and impact report. I mean, just living here and working here and raising my family here in South Louisiana and having worked on this issue for really since the beginning for over a decade. Have met many people along the way who can personally attest to the impact that these and other lawsuits have had on their on their lives, their families, and their businesses. So, by my estimation, no, it is not exaggerated, and I would suggest to you there's a lot of economic data out there that supports it as well.
One of the things at the Law and Economics Center that we like to stress is when you use the word cost, it's not just about direct economic or financial costs, but instead it's also about the opportunity costs and or the trade-offs and or the deflections. So Simone, do you see some of the costs of litigation to be a deflection or distraction away from the ability to focus on solutions?
Yeah, as I mentioned earlier, we have this tremendous issue here in coastal Louisiana. How do we protect ourselves from storms today, but how do we think long term as well? And so our challenges are super complex, and certainly some of this factors into that again. But we have enough going on here in Louisiana, and we need to make sure that we're sticking to the plan that we set forth that has been agreed to and been vetted in these communities, and communities that are obviously on the direct lines of some of this change in the future. And so we need to make sure that the messaging there is clear across the board.
And I guess I'll ask this question about everyone in relation to costs. Is there a possibility that the anticipation of potential liability costs would discourage voluntary contributions to some of the cleanup efforts and remediation efforts that that Louisiana is undertaking?
Well, I think your question begs another question, which is every dollar invested in litigation could be going elsewhere, could be going directly to restoration efforts. I mean, the industry has been for a very long time and continues to be a very strong partner in the state, not only providing, obviously jobs and economic opportunity, but investing voluntarily in the coastal restoration efforts. But I do think it's fair to question if more could be done, if we weren't in, if more could be accomplished through collaboration rather than litigation.
And I think that's an important point that I understand your question correctly, Donald.
Yep.
It's basically if you're a oil and gas company and you expect to pay $100 million in some sort of court-appointed cleanup effort, why would you then give it to the other cleanup efforts? I think that's a good question, but Melissa's point is, I think, spot on, that it's much worse than that, because if you're expecting to pay $100 million in coastal cleanup efforts, you're also expecting to pay like $75 million to their lawyers to get there. And however, God knows how much to your lawyers to try to deal with the litigation too. So there's not just sort of a question of replacement and sort of whether the money that could go here goes there instead. But there's also just tremendous waste in this approach to doing things that makes it even more inefficient towards the goal that I think everyone agrees with of trying to preserve the coast.
Excellent. So there's one other question in the queue, and I do invite the audience. We still do have a couple more minutes if you'd like to populate it with additional questions. We may have already answered this, and I'm not entirely sure the nature of the question, but what is the environmental cost to the state of Louisiana if the land loss cases go away? I'm not sure if there's an implication there that the land loss cases going away increase the environmental cost, decrease. I'm not sure. If anyone can sort of understand that question in a way that you'd like to respond, I'll throw it out to you.
Yeah, I'm not sure exactly of that question. I can tell you from our work, there's two different ways that I could maybe think about that. We have a scenario when we do coastal planning, and it's called a future without action. And that is something that we look at. Okay, this is what the future looks like. If you were, we would say pencils down, right? No more work. This is what your future could look like if we stop making any kind of coastal investments here in Louisiana. Of course, that is a future that we absolutely never want to confront. And it is something for us to say, okay, if we put this project here, what would the impact of that be, et cetera. I would say that, from our standpoint, that we've always looked at it from a, what is the economic impact of putting a project in place? How many jobs can it create? Does it protect this community? So we look at it, and we have looked at it from a benefits position of if you were to build this project, for example, the major sediment diversion, if you were to build that project in Plaquemines Parish, how many jobs would that create? How much money goes to the local and we have parishes here, obviously the parishes, how much goes to the regional economy, et cetera. So we've always looked at it from those 2 points of view, that both that future without action, if you were to not build anything, what would your future look like? But also look at the economic impacts in a more positive way about how many jobs would we create, et cetera. So that does not answer that question. It's just to say that that's not how we've looked at it before.
Great, thank you. I think this will be the last question. We've got one from the audience from Kyle McWaters, who is at Hollingsworth LLP. And Kyle asks, the case law seems fairly settled on two issues. First, simply being a federal contractor is not enough to assert federal officer as a basis for removal. And second, merely being a regulated entity is not enough of a connection to assert federal officer removal. These trend more toward, quote, acting under than related to. But do you think that this opinion broadens the scope of related to include officers acting under in the role of a contractor or a regulated entity?
Not necessarily, I think would be my answer. I think you're right that those doctrines do tend to fall more towards under, acting under rather than related to. As to whether this case expands it, I think I agree with Judge Oldham below that Congress expanded it in terms of extending it to include related to in their 2011 amendments. And this is the Supreme Court making it clear that when Congress makes that kind of change, Congress means that kind of change. And so as to how that would apply to, federal contractors or regulated entities, that I think goes to the who part of the analysis, which I think is really the first of the three steps. And related to goes to the why in terms of it's not just enough to be a contractor, but you have to be doing it for the right reasons. And the debate in this case is whether the why can be a little bit more capacious, as I think Congress made it more capacious in 2011, or, to Justice Jackson's concurring view, whether the why needs to actually be cabined pretty narrowly to a causal nexus as it was prior to these amendments in 2011.
Anyone else have thoughts on that issue? All right, I did want to reserve time for everyone to have some closing remarks, but before we get there, I want to maybe preview a discussion for another day. But Michael, if you think you can tackle these very quickly, there are two things that you raised in that I want to push back and potentially challenge you on in terms of the characterization of the opinion. The first is whether or not this says anything useful about the climate change cases. And the reason why is because if you look at what Thomas said and what Thomas cites, it's all focused on consumer fraud cases. And he cites only cases that had allegations only of consumer fraud related harm and not production or refinement related pollution harm. And as a consequence, that seemed very, very deliberate in a way to point out this example where in the text, he specifically says, oh, of course, these cases that allege consumer fraud would not be sufficiently related to the contract to be this. And then the citations are not to any of the cases that involve production area cases. So maybe for a discussion for another day as to whether or not that was a clever little way of saying, actually, I'm saying more than I'm saying here. And then the second was there does seem to be at least a lot of retroactivity flavor inside of the opinion. And although the opinion didn't get to the merits of retroactivity, there did seem to be a high level of skepticism about the nature of retroactivity going on behind some of this. So is that enough to give at least a sense of how we might think about some of the merits issues. Perhaps there's a way to address those in 60 seconds, but if not, you can tell me, let's just have another webinar on those.
Let's have another webinar, but I'll give you 30 seconds. How's that?
Sure.
I guess on the first question, the only reason why I was in any way discouraged by his remark was because he didn't need to say anything about any of those, truth be told. So the fact that he was reaching out to make a statement, and he knew that people saw this decision as carrying import in the climate context. So to choose that example was intentional. And from our perspective, we view it doesn't really matter how you dress the claims. They're ultimately the same fundamental climate claims. So I'm skeptical of any line drawing distinctions, though maybe I'll be drawing them soon enough. And I guess in terms of the retroactivity aspect, I mean, we are in active litigation with other states for imposing that exact sort of impermissibly retroactive litigation. So you're preaching to the choir on that, certainly. I think, yes, in the description of what went down here, I think you could read some sort of, a skeptical tone. But if I'm just looking at this from a litigator perspective, it's going to be hard for me to find the juicy quotable that I can then take and file a supplemental notice of authority in New York, for instance, to knock them for their same sort of retroactive liability approach. So helpful in that maybe you can help read the tea leaves, but in terms of like force of authority, I think unfortunately it offered less than I might have hoped.
Great 30-second answer. So Simone, we'll go in reverse order here. What's in 90 seconds? What are the biggest takeaways you hope everyone listening in today will understand from this discussion?
Yeah, from the non-legal perspective, for sure. Louisiana is just no stranger to change and challenges, but also adaptation and resilience. And so, as I mentioned earlier, there's decisions that we make today, whether we continue to invest in that science and embrace long-term planning, act on the size and scale of the challenge that we face, all of those things. It's going to determine the future of our communities, the economy, and our natural resources here. So it's up to us, but the time to act is now.
Melissa.
Great closing point. And to that, I would just add, from my perspective, it's clear these lawsuits are not helping to fix our coasts, but they are damaging our economy, undermining national energy policy at a time when it's more important than ever that we get it right. And they are creating uncertainty for the very job creators and companies that power Louisiana and America. And the U.S. Supreme Court, with its landmark 8-0 decision, has given us a very clear path forward. And it is important that the courts get it right in implementing implementing that decision. And it's also critically important that Louisiana leaders use this moment they have the authority and the ability to bring this litigation to an end. To refocus Louisiana's efforts on science-based coastal restoration. And it is certainly within their ability and authority to collaborate with industry that has long been our strongest ally on the coast. And so I agree with Simone entirely that now is a critical time to reconsider some of the previous actions and take the next right step.
Thank you, Mike.
This was a very welcome and important Supreme Court decision. It unfortunately did not solve everything, was not intended to solve everything. These cases are, as Melissa has explained repeatedly, a catastrophe for industry and in the end for the state of Louisiana. And so they should get resolved. But this opinion, I think, brings everyone a step closer to doing that by setting out clear principles for how these cases should be in federal court. Again, it didn't answer everything. It only answered this case. It left a lot of questions unanswered. But I think it gave the tools necessary to answer those questions effectively and do so in a way that puts these cases in federal court, which I think will be very helpful towards actually resolving this broader Louisiana coastal lawfare issue in a fair and just way. And so we'll see how long it takes to get to that point. Hopefully the courts in Louisiana will act expeditiously to get these cases in federal court and resolve them in ways that minimize all of the just tremendous regulatory waste that is going on with this litigation.
And Michael.
Yeah, one of the reasons why I squawked when you were mentioning institutional competencies earlier is honestly, I view that as maybe the fundamental question in the case and maybe the best answer that the court gave us. From West Virginia's perspective, we're kind of constantly wrestling with the question of, is it Congress or is it the executive or is it states or is it federal courts versus state courts? Who really are the best decision makers to wrestle with these serious issues? I think that maybe is where people sometimes get confused. They see us come into these cases and think that we don't, for instance, recognize the seriousness of the problems, or we don't see that environmental issues are real and genuine, just as economic ones are. We do, and I think all states do. And it's just a question of what's the clearest, most efficient, most effective path to finding solutions to those serious and substantial problems. And so from our perspective, the best path, we would always prefer the legislature, I think, as a first option. But in this case, in a situation where litigation has become an avenue that some have taken, it at least needs to be in a venue where the serious federal interests at play are acknowledged by a federal decision maker. So fundamentally, we were happy about the court's choice to place these cases there.
Great. Well, thank you all for joining us in the audience. I hope that this was an informative and useful discussion for all of you. As mentioned, it is certainly not the end of the discussion, but hopefully one which is a little bit richer as a result of your engaging with us today. Thank you to all of our panelists for your expert guidance on these very important issues. And I will mention that the Law and Economics Center does all of our programs as a public service. So if any of you would like to help keep the Law and Economics Center running and active, please do go to masonlec.org and click on the donate function and send some support our way. But also go there to look for additional programming coming up, masonlec.org. And we look forward to you exploring the opportunities to engage with us at future events and to seeing you at those. With that, we bid you a wonderful afternoon and evening, and we look forward to speaking with you all again soon. Thank you very much.